Welcome back to the channel Future CS and Future CMAs, and welcome back to the concept series. Concept series part 2. So concept series part 1 we have discussed about, we have unfolded the concept of global deposit receipts and how a company will be able to raise finances from a foreign investor, from a foreign jurisdiction without much of a hassle, with less amount of compliances but raising finances from the foreign investors. We slowly build our way into the technicality of the logic global deposit receipts. Now in this particular video, concept series part 2 will be taking on the famous case study, the very big case study called as Royal British Bank versus Turquand, which happens to be a part of your CA foundation, CA Inter, CMA Inter, as well as your CMA final. We'll unfold this concept as well clearly from the very basics. We'll understand why this concept came into existence, what actually happened in the case study, what was the reasoning why this law was made. As you all know, this case study was the stepping stone for creating indoor management. The concept of indoor management are also called as Turquand's rule. So we will start with this case study, but before we start with the case study, I want you guys to be having a proper clarity of what is constructive notice. So let's break it down as usual with the basic concepts of what constructive notice is, what is expected in the process of constructive notice. Forget about a company, guys. Let's take a simplified, even more simplified example of two people going and entering into contract. Whenever two people go and enter into contract for business purposes, the terms and conditions of them will be discussed between them. As we have learned at the foundation level that any contract, any agreement is entered only when there is consensus ad idem. Both the parties must be agreeing on the same sense in the same matter, same categories. So coming to this particular concept, the terms and conditions of the contract should also be agreed by both the parties. If they are agreed by both the parties, can I indirectly say the rules and regulations on which the other party is ready to deal in the contract will also be discussed between the parties? So what rules I want, what rules the other party wants, we'll discuss both the rules and regulations. If at all we are comfortable with the rules and regulations agreed by both the parties, then we'll go and enter into a contract. Are we clear in this logic, guys? That rules and regulations will be discussed between parties before they enter into a contract. But now slowly modify this logic into a company form of a business, where a company comes and enters into contract with a third party, and now we have to again discuss about the rules and regulations. But sir, rules and regulations discussion is possible only when it's a natural person. But company happens to be an artificial person. It cannot come and discuss about the rules and regulations on which it is ready to deal, on the terms and conditions on which it is ready to deal, will not be discussed by the artificial person. Henceforth, we started drafting a document called as MOA and AOA. These documents MOA and AOA will contain all the rules and regulations of the company which it is ready to deal with when entering into a contract with a third party. So given the fact that these documents now become vital for entering into any transaction with a third party, with an outsider of the company, we have to make sure that these two documents the company has to provide it to every third party. But sir, there's a problem in this logic. Company does the business at a very large scale. It will be having lakhs and thousands of crores of third parties, outsiders during the procedure. Is it practically possible for me to give the entire MOA, entire AOA to every single third party every single time? Not practically possible, because the third parties are huge in nature. This problem did not arise when it was partnership firm. We used to actually provide the rules and regulations. But when it comes to company form of a business, because of the large scale of business, it is not possible for them to actually provide this MOA and AOA to the third parties. Hence, what have we decided is we'll do an alternative. So what's the alternative, sir? Before we go into the alternative, understand the background of this alternative. What happened at the time of incorporation of a company? The subscribers to memorandum have prepared multiple documents, out of which the utmost important and the foremost document was memorandum and the articles. Once these documents, for the purpose of incorporation of this company, the subscribers to memorandum prepared MOA and AOA, the rules and regulations of the company, and they were delivered to the ROC. And ROC, rather than returning these books back to the subscribers, they have kept a copy of these books available with the ROC, that is in the given age in the MCA portal. On the MCA 21 portal, you will have all the MOA and AOA of every single company. And ROC states that I'll keep these documents for public inspection. They're open for any person to come and inspect these documents. Come to the ROC, pay a little amount of nominal fee, the ROC will provide you these documents. In the given case, go to the MCA website and you can check the MOA and AOA of every single company out there in the market. So these MOA and AOA now are considered as public documents because they can be inspected by any person. Now, given the fact that they can be inspected by any person, now starts the logic of constructive notice. What do you mean by constructive notice, sir? Actually speaking, the company should have given notice of its rules and regulations to the third party, but rather than giving the notice of rules and regulations, we'll assume that we have given the notice. The constructive notice is a logic that we take a assumption that the notice of MOA and AOA, the rules and regulations of the company, have been actually given to the third party. Will take an assumption. In fact, the documents are not given, but will take an assumption. Sir, how can you take this assumption in the process? States that an outsider, a third party, whenever he wants to come and enter into contract with the company, he doesn't come to the company directly. He first has to go and approach the ROC, request the ROC, he requests the ROC, asking the ROC to give what? The MOA and AOA of the company with which they want to deal with. Once the ROC provides these documents, they'll read and understand, inspect the documents properly. Once the inspection is done, they have understood the document in the rightful senses, then they'll come and enter into contract with the company. That means now the company, based on the logic constructive notice, is under the assumption that as and when the third party comes to the company, they might have already approached the ROC, they might have already have knowledge of MOA and AOA. Will pretend in this assumption that the third party outsider already has knowledge of MOA and AOA. So what's the conclusion on this, sir? If a third party has knowledge of MOA and AOA, he will enter into transactions only according to the rules and regulations. If at all the third party doesn't have knowledge of it, the third party will enter into a transaction which is beyond the rules and regulations of the company, which happens to be ultra vires transaction. As we all know, ultra vires transaction is again void, where the company is not liable. Indirectly, who will be held liable in the process? So outsider will be held liable. So we'll conclude this logic from two perspectives. We'll use it again in the indoor management, guys. So carefully answer. So one second. So who is protected in the process of constructive notice? Who is given benefit of constructive notice? Yes, you got it right. Who is protected here? The company is being protected. And in the same logics, who is made liable under the process of indoor constructive notice? Who is made liable here? The third party, the outsider, has been made liable for the procedures of constructive notice because of the fact that he did not have knowledge of MOA and AOA. Indirectly leads into the concept of ultra vires transaction. I hope this concept is clear for you. With this conceptual clarity of constructive notice, let's come back to our concept, Royal British Bank versus Turquand. So what happened in this case, sir? What happened between Royal British Bank and Turquand? One second. Chalo. So what happened in this Royal British Bank versus Turquand? There was a company which wanted a loan from a bank called as Royal British Bank. The company was into the business of railways. There's a huge company's name. So for the time being, for the understanding, we'll simply use it as a railway company. So what's the concept here, sir? A railway company wants a bank loan from a bank. The bank's name was Royal British Bank. And remember, Mr. Turquand has not yet come to the story yet. He'll make his entry at the later part of the cinema. Okay, so come back. So what happened here? The railway company wants a loan from the Royal British Bank, for which they agreed to provide bonds. They stated that I'll give you bonds and for which I want a loan. Then now classify the concept here, guys. The railway company here is a company and the Royal British Bank here is a third party. Now go back to our presumptions here. Third party, before entering into contract with the company, should have knowledge of MOA and AOA. Hence, for the same logics, the Royal British Bank, what it has done is, it went to the ROC for the purpose of, one second. It went to the ROC and requested the ROC for the documents MOA and AOA and actually inspected these documents. And after inspection of these documents, the Royal British Bank came to the conclusion that, sir, this railway company can take loan, but they can take loan only and only after getting a proper approval, proper resolution passed from the shareholders. then the Royal British Bank, with the concept, with the knowledge that resolution must be passed, comes back to the railway company, comes back to the story, states that, railway company, have you passed your resolution? Then railway company states that, yes sir, our board of directors, for the purpose of this approval, have actually conducted a general meeting, and in the general meeting the resolution was also passed. And the fact of this procedure, this will be the most important part of the case study here. What happened here? The articles of the company stated that the resolutions so passed for obtaining a credit facility, obtaining a loan, must always be passed along with the limit specified for loan. Simply speaking, shareholders agreed for the loan, but shareholders agreed for the loan up to a specified limit, assuming say 5,000 euros, assuming say 3,000 euros, assuming say 2,000 euros. The limit must be set. If this limit is not set, the resolution is said to be not properly passed. If it is not properly passed, the board of directors don't have authority to provide, to take, to avail a loan from any third party. But because of the fact that the resolution was passed, but the limit was not specified by the railway company's shareholders, they made a non-compliance in the procedure. That means, what's the conclusion on this topic, sir? The resolution was not properly passed. Board of directors have no authority to raise money from a third party. Now, the railway company has stated that we have passed resolution, and Royal British Bank, believing on the statement that resolution was passed, actually provided a loan. Actually provided a loan of how much? 2,000 euros. Remember, this happened in the UK, so 2,000 euros of loan was provided, and 2,000 was a very huge amount back in the day. And slowly, after a certain period of time, this railway company went into losses and became insolvent. It was declared as insolvent. As soon as it is declared as insolvent, or as we all know, insolvent person is an incompetent person, and in case of insolvency, we'll appoint a person called as official liquidator. There comes our hero, Mr. Turquand. Mr. Turquand was appointed as a official liquidator of the railway company, and he started analyzing all the procedures for payment of creditors. And the Royal British Bank came running to the Turquand, stating that we have bonds from the railway company. I want this 2,000 euros to be repaid. Then, after checking the books and the minutes of the company properly, the Turquand stated that, sir, bonds are fine, but these bonds are unauthorized. They're not properly passed, approved by the shareholders. They did not mention the limit. Because of the fact that they are unauthorized, I'm not responsible for paying this money to you. It was an ultra vires transaction. Third party entered into contract with the company without the company's board of directors having authority. It was an ultra vires transaction. I'm not responsible for this transaction. Then the Royal British Bank crying goes to the House of Lords, stating that we have given bonds. How could we verify whether resolution was passed or not? And the trial started. Once the trial started, the judge started analyzing what happened in the procedure, had documents, had information, had discussions between both the railway company, the Mr. Turquand, as well as the Royal British Bank. And once the discussion has happened, the judge came to the conclusion. Listen carefully, guys. This will be the important part, the break and make of this particular case study. What happened here? The general meeting of the company is something which is accessible only by the shareholders of the company. Shareholders have access to enter the general meeting. They actually know whether resolution was passed or not. They know actually whether resolution was mentioning amount or not. They have proper internal information about the company. But sir, that's fine. What about an outsider? An outsider is not accessed into the general meeting. He doesn't have access. If he is not having access to the general meeting, if he is not allowed to enter into the general meeting, if he is not having information about the internal activities of the general meeting, it is not possible for him to inquire whether resolution was passed or not, whether resolution mentioned a limit or not, whether resolution was properly passed or not, is outside the knowledge of the third party, and it is not even possible for him to inquire about it. Then the judge stated that because of the fact that outsider is not possible, he is not in a position to verify the requirements of the inside information of the company, the judge stated that the internal matters of the company are the headache of the company itself, are the problem of the company itself. You cannot expect a third party to inquire into the internal workings of the company. It is not the responsibility of a third party. Third party can take an assumption that the internal workings of the company, the internal management of the company, the indoor management of the company have been properly been implemented. With that assumption, if a third party enters into a contract, we'll assume and will protect the third party and will make liable the company. So what was indoor management here? Indoor management concept applies if the third party outsider has satisfied two conditions. The first condition, he must have knowledge of MOA and AOA, which our third party, our outsider, that is our Royal British Bank, had actually knowledge of MOA and AOA. They inspected these documents, and along with this knowledge of MOA and AOA, they must also have no knowledge of internal irregularities of the company. No knowledge of internal irregularities, internal management of the company, because they are not able to inquire about it, and if they are not having knowledge, will protect the third party, and we are making liable whom? The company. So give me the wordings here: protect third party and make liable the company. If you now link the pattern, if you observe the pattern in the process, the constructive notice stated that we are gonna protect the company. Indoor management states that we are gonna protect the third party. The concept is exactly opposite to each other. That's the reason indoor management is also called as an exception to the logic, constructive notice. I hope the concept is completely clear for you. That's the entire process of how a indoor management process concludes for you. If at all you have any doubts in the process, if at all you have any factual doubts in the logic, please do leave a comment on this particular video. Like the video if at all you have gained any knowledge out of it. Subscribe to the channel. We'll see you on the next one. Thank you guys.